what the court invited in terms of additional briefing. I'll go into that, but that's exactly why it's problematic here. And then to the contrary, we are under a very tight schedule, as the court's aware, with AB 734 and the rules of court, and there's no provision allowing for an amicus brief in under those rules, and those really is what apply in this case. And we completely understand the court's need for additional time, but the parties all very much strictly adhere to these rules throughout the case. And we're talking including the court's direction for the petitioners to file a joint brief so that they could coordinate amongst themselves on what issues they believe are at front and center for this case. And the parties also filed a joint case management statement just a week ago that outlined a proposal on how the hearing should go and asked for court direction. And there was no mention by petitioners in that joint statement of any amicus brief, which is ironic and definitely suggestive of some perhaps not in good faith, because the amicus brief was filed just hours after we filed that joint case management statement with the court. But here it's particularly troublesome because, as CB says in its application, they actively participated in the EIR process. They submitted a 54-page comment letter on the draft EIR that the city responded to in detail. But they decided, unlike petitioners in this case, not to sue within the 30 days. And that statute of limitations for CEQA is mandatory and jurisdictional, and there's no authority that allows them to decide to wait to the last minute to then, instead of filing a CEQA lawsuit, to ask to participate in this as an amicus to bring up the very same claims that they could have brought in a lawsuit, and they submitted letters on and participated in the CEQA process during. And the city and the real parties really were entitled to that certainty that the statute of limitations provide here. We had an idea of what we were dealing with in terms of the parties in this lawsuit and the claims. And the parties have all adhered to this date. And so to have this come in at the very last minute really undermines this mandatory jurisdictional part of the CEQA statute of limitations. And I would say that CBE is a very sophisticated CEQA plaintiff. They participate in many, many lawsuits and bring many CEQA cases. They absolutely know the rules. They knew how to bring a petition. They chose not to. They waited until now to do so, to try to raise claims now. And the problem with the amicus brief, which goes then to the court's invitation on how to respond, is that it does raise new arguments and evidence and actually enlarges the case before the court. And there's a general rule that amicus accepts the case is how they find it. And this is at the Court of Appeal usually, and that they're not allowed to launch out into a judicial expedition unrelated to the actual record before the court. And this is critical here because the record has yet to be set. It's improper. It would be completely improper for the court to rely on any claims or argument newly brought by CBE in this case, because the court is confined to what the petitioners raised. And so this really is an invitation for error, to be just respectfully honest, Your Honor. And when we say that there's new arguments, they raise new claims on greenhouse gas emissions, on air quality, on truck relocation, and on hazards. These are all claims that could have been brought by CBE in their own lawsuit, or petitioners could have raised them in their brief. They chose not to. And so because of this, that opportunity has just passed. They've missed that chance. And CBE appears to rely on information not in the administrative record. There's a long list of other authorities in this brief. These newly raised claims further violate CEQA. It's really trying to expand the scope of CEQA beyond the environmental impacts of the case, and raises concerns about socioeconomic impacts and equity issues. And while the city definitely shares these concerns about West Oakland, this lawsuit isn't a referendum on the project and not really the time to broaden the scope of CEQA. when you even look at the content and scope of the amicus brief, there's, as we mentioned, there's limited citations to the administrative record. It attacks portions of the EIR without any explanation of what the EIR says or provides. It makes no attempts to state, much less meet a standard of review, a burden of proof. It's once again, it's an invitation for error. It's that they did not file suit and present their argument as a CEQA petitioner. And so allowing this out here for the potential for the court to rely upon is an invitation for reversible error at the Court of Appeal. And that actually then raises this issue in terms of how do we respond, and giving an opportunity for petitioners who have already had 110 pages of briefing to then get additional, they'll get the 25 that CBE has provided and another additional 10. But for us, for respondents and real party, we're gonna have to spend our response actually showing how it goes beyond the arguments raised. It's gonna be a good part of the answer is going to be like, hey, really saying to the court, you can't consider this. So when it comes down to it, if an amicus brief is supposed to be something that's helpful to the court, it's actually just creating a lot of procedural confusion, substantive confusion for the case, and it's not helpful at all to the court. And that's the actual standard when it's at the Court of Appeal is this helpful? Is this going to be helpful for deciding the issues before this case? And at the Court of Appeal, you have issues of, important legal issues, of precedent. The only issue here for the court is whether or not petitioners, not CBE, have established their burden of demonstrating that the city's decision on CEQA decisions are not supported by substantial evidence in the record. The CBE amicus brief does not help the court in that respect at all. It really just adds additional procedure and additional just confusion to the issues. And then I have to mention that, kind of what I started with, that the timing of this is really suspect. The parties have known that we've had this hearing on the merits since August 19th, since May 31st. The parties have filed 2 case management statements with the court, including one just a week ago today, where if there was an issue, an idea of inviting amicus to participate, that's where it should have been raised. The fact that there was no mention by petitioners when they were supposed to meet and confer in good faith on the hearing date, on the conduct of the hearing that we filed last Friday, no mention of this at all is just a strong indication that there's just not good faith, unclean hands. And it just seems intentionally disruptive to what was going on. And I just have to say, CBE is well aware that this was under an expedited CEQA review. They actually they submitted a letter to the city in January of 2022, which is that, I can even give you the AR site 16152, where they actually said like AB 734 establishes an expedited judicial review process for the project. So either they've been working on this all along and this was their plan and they waited to the last minute, or perhaps they just decided that the briefing wasn't sufficient and they needed to add something in. But either way, it circumvents the court's page limits. It's going to add confusion to the case. I mean, the amicus adds 8 pages, for example, of briefing on GHG, where petitioners only spent 1 page in their opening brief. That's exactly our point, Your Honor, in terms of how is the court going to be able to decide what is properly in front of this court? It's really an opportunity for CBE to get a second bite of the apple. It's an opportunity for petitioners to give even more paper and try to fix things. And we really strongly encourage the court to just deny the petition outright, because the application outright, because it doesn't really serve any purpose. It only will confuse the issue. I think my colleague, Mr. Manley, might want to talk a little bit as well, or I don't know. I don't want to monopolize everybody's time on my side.
Well, I'm also happy that you have monopolized the time and taken all the argument that I need on your side. But if anyone else on respondent wants to add something as opposed to me doing.
Thank you, Your Honor. Whit Manley on behalf of Athletics Investment Group. We do agree with Ms. Dively's position. I do want to add that in going through the effort to have AB 734 enacted, certified by Governor Newsom, the sole benefit really is expedited schedule for judicial review. We've all known that, including CBE. And this really does appear to be calculated to be the equivalent of rolling a grenade into the room at the last possible second. Ms. Dively said this amicus brief application was filed a couple of hours after our joint CMC statement. I actually received it a couple of minutes after I received notification that the CMC statement had been filed. Pretty extraordinary for that to happen a couple of minutes after we file a joint CMC statement. Now, I will credit the petitioners collectively for working with us to make sure that we adhere to the time schedule that's established by the rules of court under AB 734, and we appreciate those efforts. CBE appears to be attempting simply to confuse things and delay things, and I don't think those tactics should be rewarded. I do want to say I appreciate the court's position with respect to the hearing on the merits. The court would like an additional 2 weeks to be prepared. We appreciate that. We applaud it. We'll be ready to go on September the 2nd. But we also agree that the amicus brief doesn't really add anything. And, you know, to get into the substance of the application, I'm not going to go into detail, but I do want to note all of the arguments that CBE makes fall into two categories. They're either repeat arguments that are already made, in which case that's not particularly useful to the court, or they accuse the city of not doing certain things. How are we going to respond to that without saying, which we can and will, yes, we did do those things. We did undertake that analysis, and they just simply ignored it. And for us to be able to do that in 10 pages could be very, very difficult. Not that I want to burden the court with additional pages. You already have 175 pages of briefing, and now CBE wants to file the equivalent of another 25-page trial brief. It's just improper, and as Ms. Dively mentioned, it's fraught with opportunity for wandering up a box canyon from which there's no escape. So we do hope that you just simply deny the application. It's not necessary. Thank you.
Thank you. Any other respondent need to be heard at this point? And let me briefly from petitioner, then I'll turn to CBE.
Thank you, Your Honor. It's Ron Van Buskirk. I'm going to try to be a little more succinct than what you just heard. Your Honor should allow the amicus. I agree. We all agree they can't enlarge the substantive issues in the case through an amicus. They are not. They address three main issues, which are in the case: the greenhouse gases, air quality, and contamination remediation risks. But what they bring, Your Honor, is a different and important perspective. These are the communities, East Oakland, West Oakland, and Chinatown, that will bear the brunt of whatever significant impacts this project has, more than anyone else. And CBE, as a representative of those environmental justice communities, certainly brings a perspective that will be helpful to the court and to the Court of Appeal if this case goes there someday. I think that's really important for the court to hear. Just a few quick points on rebuttal. Of course, the filing is discretionary with the court. We all know that. But there is absolutely nothing, and I mean zero, in AB 734 that in any way suggests amicus fees have been eliminated. There is nothing. Now, as to the 271 days, we all know that, but we're well within that time limit. So there's no threat to that. On the timing, Your Honor, generally amicus has to wait for the close of the party's main briefings. That's the rule written in the Court of Appeal, and it generally followed in trial courts. So the reply briefs only closed August 8th. So an amicus like CBE had very little time after waiting for the main briefs to close, given the court's schedule. And we understand the court schedule and fast track, but it is what it is. So they got their brief in roughly within a week after the main briefing closed. Seems to me that's more than satisfactory compliance, and the implications of bad faith were just misguided. In terms of the case management conference statement, nobody knows for sure if they're going to file until they file, and that's that. So, Your Honor, finally, on the so-called extra record materials, that's to some degree that's what amicus brings to a court. We all know what Brandeis briefs are, and sometimes they do and are allowed to submit reference other materials, and I can cite you to the runner guide for that if we have to go that deep. So, Your Honor, there is zero chance that if you allow CBE to be heard on behalf of their communities along with everyone else, that you're going to be reversed. There's zero chance of that. Okay.
Well, in terms of anything I do, I don't think there's a zero chance of anything.
Well, I
won't
think
take that much experience. There's no such thing as a slam dunk on any issue, but be that as it may, I would like to hear briefly from CBE in response, and then I'll tell you what I want to do.
Thank you, Your Honor.
Thank you, Your Honor. Again, Shauna Lazaro on behalf of Amicus Communities for a Better Environment. I appreciate the opportunity to appear this morning. I will say I also appreciate the observation that CBE is an experienced CEQA litigant. Going back to, the earliest trial court amicus brief that I recall is from 1995 in a CEQA case when the San Francisco Alameda Superior Court allowed Sierra Club to file as a friend of the court in a challenge to a proposed card room. We've had Environmental Defense Fund in San Francisco Superior in our challenge to AB 32, which was a CEQA case. It's not routine for superior courts to accept and hear from amici, but it's also not unusual. And the idea that because CEQA has a statute of limitations, we would not be permitted when a court finds it helpful to submit a friend of the court brief is not really based in anything but conjecture. AB 734, as Mr. Van Buskirk pointed out, is entirely silent on amicus briefs. And it was very interesting to hear that the expedited judicial review provision is the only benefit from that statute. There's quite a lot of substance that I would hope has benefited the city and the athletics. I would also point out that CBE, along with a couple of other environmental allies, are currently amici in Alameda Superior Court in support of the athletics investment group in their lawsuit against Schnitzer Steel. So it's somewhat ironic that they are trying to keep us from appearing on behalf of petitioners, including Schnitzer Steel, in a case it's related to the same communities. Just a little bit of irony there. I will say that to the extent that we are experienced CEQA practitioners, we were very careful not to expand the scope of this proceeding. I don't personally feel that additional briefing is necessary to address this. Respondents already submitted an opposition to our application. We would be happy to provide a little bit more explanation about the benefits that we believe we could offer to the court. But for instance, the main extra record document to which our brief cites is the remedial action plan, which really should have been part of the record, but because it was prepared after the EIR was finalized, it does not appear to be in the administrative record, so we couldn't give an AR site for it. I would say that the perspective that CBE can offer is one that I would really hope that is important to the court and will assist in this decision. The idea that it would somehow be unhelpful to hear from the community members who will be affected is frankly a little bit offensive. So thank you, Your Honor, and we are prepared to submit.
I have a question though. You made a reference. Was there an opposition to the amicus? I don't see one in the record here and I haven't seen it. There was one filed?
Yes, Your Honor.
When was it filed?
Monday.
We filed it on Monday, Your Honor, before the amicus brief was actually accepted by the court because they had attempted to file and serve it on Friday.
Okay, well, it has not made it into the record of actions and I haven't received a copy of it. Let me do this. If you would please do me the courtesy by the end of the hearing of making sure a copy of that is emailed to my departmental clerk. And before I make a final determination about any additional briefing or anything else, I want to at least read it and see what you've said. Let me be clear about a couple things. I totally agree I have the discretion one way or the other. On a matter of this magnitude, I'm inclined to be more open than closed. This is a very important set of issues, and there is I think there is at least a threshold argument that CBE represents communities that may not be fully represented in this case. At the same time, I want to be absolutely clear. I'm not going to let this be the camel's nose under the tent to raise any new issues. The scope of this hearing is limited by what the petitioners have brought. So I want to be clear about that. So what I will do, I will look at whatever your opposition is. I am nevertheless inclined, unless it's there to permit some modest additional briefing from the respondents. I'm not sure there's anything from petitioners that I want to hear about here at this point. What I really want to hear from respondents, if it's not covered in your brief, is number one, the extent you think this motion, this amicus raises issues that are outside the scope, that I want to know. And number two, to the extent that's within the scope and it has not been addressed in the briefing, I want to give you an opportunity to respond to that. So it's a really limited issue. But before you write anything, let me read that brief and decide whether anything further needs to be said. I'm not making a final decision about whether I will consider the CBE brief until I read your opposition and if I permitted any additional briefing on your side. It's not an arguing amicus, it's simply the brief. I'm not permitting CBE to participate in the hearing itself. So I'll leave that as it is for the moment. I'm not hearing a problem with the hearing time of September 2nd at 10:30. I briefly saw the suggested format of the hearing in the CMC statements. I have no problem with that, but I do want to suggest that you wait and see what my tentative ruling is, which may inform how you want to structure the arguments. I have no problem with using screen sharing to show me specific documents and the like. The length of the hearing, I'm going to wait until I finish the TR. We certainly will go the full morning, which would mean you'd have about 2 hours. I want to consider, after I've issued the TR, how much more we need. But for the moment, assume you have at least an hour for each side. You may have more based on what I conclude when I finish my TR. Anything else today we should do other than continue the matter as I've discussed?
Your Honor, Whit-Manley, if I could ask one specific question.
Yeah.
If the court does accept CBE's amicus brief, there are a number of citations to HTML sites. There was not an accompanying request for judicial notice. We believe those citations go outside the record and therefore we don't think the court should consider them. But should we be filing a motion in opposition to a non-existent request for judicial notice, or what should we do?
No, there is no request for judicial notice. You're free to tell me in any supplemental briefing why you think I should ignore it or not. But I don't have, an amicus isn't making that request in front of me. The record is what the record is.
Thank you, Ron. I was a bit stumped because of that. So that guidance is helpful. Thank you.
All right. Anything else
And
today?
Your Honor,
Yes.
Tim Kremen on behalf of the city.
Yeah.
Just one question on today and one logistic question. If the court is inclined to allow an answer, we've opposed the application, but if you accept it and allow an answer, we strongly feel like petitioners should have no further briefing in this matter.
That's what I indicated.
Okay, I just want to make sure.
I don't think we need any piling on here.
Okay, and the second thing is their amicus brief does present a number of issues that expand the scope of what's before the court under the parties briefing. If you give us 10 pages, always like a belt and suspenders approach, we're like, that's a new claim. We don't have to respond. But then you sort of feel compelled to say, but if the court disagrees, and if you're giving us 10 pages, it puts us in a really difficult position. And I just wanted to understand the court's thought, because we just feel like if it's outside the scope of petitioners, we should say that and move on. It presents some risk for us.
Well, it presents risk for everybody. Let's put it that way. But at the same time, I want to be clear that this is not going to expand this case in any meaningful way. So it should be pretty clear what's in it. If you have any doubts what's in or out, you tell me about it. But I think if you clearly tell me these issues are outside, these are the new things, or it's already been addressed in the papers, so we don't need to repeat ourselves. I think 10 pages is sufficient to get to that. It is an amicus brief. It's not going to expand the issues in this case.
And thank you, Your Honor. And the one logistic question without holding the court to this, do you have a sense of how many days in advance the tentative may come out? And I'm not, is it like the day before, which is the tradition?
No,
it's just
I'm going to try to give you at least a couple days notice going forward. And I'm working with my research attorney in our schedules and to make sure we have enough time. That's why I put it over. Theoretically, we could have issued something for today, but I didn't want to rush it. I wanted to make sure that you had enough time to review it, but also that I was comfortable in this very large record with what ruling I'm going to make. So I hope to have something out, frankly, if not the end of next week, but the very beginning of the following week.
We appreciate that.
All right. All right. Thank you all. I'll see you in September.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Your Honor. Your Honor.
Okay. Which brings me to the Martin case.
Thanks, Judge Vice Lickman.
All right, that's not us, the Martin case. We're done there.
All right. Thank you all for your patience. Originally, I was going to have 2 hours of that before you showed up. So I cleared my decks as much as I could for you to get ready to. Let's have appearances. I think we have a court reporter again?
Okay, that's another case, folks. So that's the Martin case has nothing to do with us. But let me explain what's happening. And Dave says, did the city put this much effort in keeping the Raiders there? I don't recall. Let me explain what just is going on here. That hearing was to set a date for the latest lawsuit that the East Oakland Stadium Alliance has filed against the Howard Terminal effort. And this specifically is against the results of the Bay Conservation and Development Commission. And the argument is that, and I should really change the title to reflect that, but it is an anti-Howard Terminal lawsuit. So the title is thus. But the contention, as Mike Jacob has stated, and I'm trying to get him now. In fact, let me see if I can just call him right now. I'm just going to take a shot in the dark and see what happens here. Mike Jacob is a lawyer for the Pacific Shipping Maritime Association. I just sent him a text, so I'm going to assume that he's talking, getting his paperwork.
Hi, you've reached Mike Jacob with EMSA. I'm not able to take your call right now, but please leave your name, number, and a brief message, and I'll get back to you as soon as possible. Thank you very much.
Hi, Mike. This is Zenny calling. Left you a text. Try to see if you have just a minute or so, or whatever you can spare for some comments. Anyway, that lawsuit I'm talking about, and this preliminary hearing was about, is one that I referred to as frivolous. And unless you're just joining us, you basically heard the defendants say, hey, there's really no need for this. And the comment was that, essentially by one of the attorneys, that this is an effort to just basically pile up more paperwork in opposition to the project and to what the BCDC had done and the EIR itself. So that's what that hearing was about. Now, the big news here is that they're going to actually have their court hearing for the lawsuit that the East Oakland Stadium Lions filed September 2nd. So that's what the judge said. He hasn't made a decision regarding the friend of the court brief, and which I think is interesting because he could simply have rubber stamped it, but there's a obviously the arguments that the defendants made did not fall on deaf ears regarding what could be colloquially described as the frivolity of the effort. I'm not saying that to make light of the East Oakland Stadium Lions' overall concerns, which, if you are not familiar with them, are these. And I'm going to give you a short explanation from a historic point of view. What the maritime interests, including Schnitzer Steel and others, are concerned about is what I would call the San Franciscanization of the Oakland waterfront. Again, the San Franciscanization of the Oakland waterfront. I'll repeat that one more time. The San Franciscanization of the Oakland waterfront. And what that means is that prior to the 1930s, the San Francisco waterfront was used for shipping, wartime efforts that continued through the 40s, through the 50s. In fact, you may remember a number of very famous movies that included San Francisco in them that were focused on stories that occurred during World War II, most notably the Caine Mutiny, starring Humphrey Bogart. Now, after that, the San Francisco waterfront became more known for tourism with Fisherman's Wharf and the dramatic growth of Fisherman's Wharf, and then the ability to accommodate seagoing ocean liners for tourists who simply wanted to come in. And that activity slowly pushed out and shrank the common traditional actions and activities that the Port of San Francisco was known for. And so there's always been a fear for decades that at some point the same economic change could happen to the Port of Oakland and its lands. And so there are not a few small number of people who see the waterfront in Oakland as being threatened in that way by Howard Terminal and the Athletics' desire to develop there. And I'm not saying I'm against Howard Terminal, but I'm simply giving you the perspective of someone who's now been around long enough to have, and my background's urban planning, and I got my master's degree from Cal and my undergraduate from Texas Arlington, but I went to Skyline, and I grew up in Oakland since I was 12, April of '74. I have seen this change because I paid attention to it as a person who's been interested in planning. Then, of course, went to planning school and worked for the Oakland Redevelopment Agency right out of planning school. So I had a front row seat and have had to have one for these developments over time. And that's how we got to where we are right now. And so what happened was that Mayor Schaaf, rather than insisting that the Athletics build at the Coliseum and say, hey, we'll help you build basically a table, okay, so that the problem of sea level rise will not impact the development there, or East Oakland, which is a tall infrastructure development order, but it's got to be done. You can decide to select Howard Terminal. Basically, Libby gave them an either or choice, and the Athletics, because there was no language saying that they couldn't do it, they chose both. In the ENA, they chose both. They chose both smartly, and the mayor did not object. And this is something that I actually referred to in a video blog some time ago. This was right after the Athletics tried to get something going at Laney College under the old idea of building a ballpark there, even though the initial one had been shot down. I really was all for it, but the number of people against the Athletics building a ballpark there was shockingly high. I say shockingly because you had students there who told me on camera that they didn't want it, because their concern was, number one, guess what? Affordable housing, okay? The housing situation from a cost standpoint has become so bad that it has altered the course of development, not just in the Bay Area, but it's altering the course of development throughout the United States. Again, it's altering the course of economic development throughout the United States. And America has to get a handle on its housing cost problem before the homeless, or the unhoused situation gets more out of hand. It's already out of hand as far as I'm concerned. And it's so bad we can't catch up to mitigate it, to provide people with homes, a roof over their heads, the American dream, right? So let me go to answer your questions. I hope that frames where we're at right now. Jay Boogie says the A's were in Vegas yesterday meeting with Phil Ruffin, the owner of Treasure Island, to build on the Las Vegas festival grounds. That site makes more sense than the site by the MGM Grand. I'm not going to deliberate on that right now, and because I'm going to come back to that later, actually in a follow-up show, because there's a lot more information there. I could talk about that for a long time, but this is not the appropriate time for me to do so. Not to say that I don't want more comment on it, Jay Boogie. I don't want to be misunderstood, okay? So it's a great point to bring up, right? But it's kind of in that direction. Dave Compton says, did the city put this much effort into keeping the Raiders there? I don't recall. No, I do. And Dave, it's a good question. It was actually a different time. Let me do something real quick. Let me exit the solo layout here. It was go back to the I was trying to go back and anyway, that's not an important thing to change. Let me explain this. When the Raiders left in 1981 officially, there was an immediate effort to first replace them with some type of football activity. And along came the USFL. And Oakland had a USFL team, the Oakland Invaders, with the fist and the lightning bolt in California blue and gold colors. And that actually lasted for a little while. It didn't quite fill the void for the Raiders. I mean, what can? We're talking about the Raiders. But as that was happening, there was always a dialogue with Al Davis. And so when it became clear that what the LA County Coliseum Commission promised Al Davis and the Raiders was not coming to reality, the city of Oakland was in a position, put itself in a position to make an offer for Davis to move back to Oakland. My point is this. Compare that to today. Today, there has not been an effort to bring the NFL back to Oakland because of the personal wishes, really primarily, let's get it out of the way, of Mayor Schaaf. Mayor Schaaf has been on my show and said, and made comments that were as inflammatory as the NFL raped her. In other words, Mayor Schaaf made it about her. And yeah, did Mayor Schaaf receive substandard treatment by the National Football League? Yes. But did Mayor Schaaf also make retaining the Raiders less about Oakland and more about her? And the answer is yeah. Because as I've said before, and I'll say again, Libby took an inordinate amount of time putting herself out as the negotiator for the city and putting herself into a pool of people she had not worked with and had reason to work with in a complex financial arena until the stadium issue. So she gave her presentation to NFL owners in New York City in November of 2015. I was there outside with other media. Eric Grubman, who is the NFL executive vice president of NFL properties and the stadium point person, gave her, and that video is here at Zenny 62 Media, a Boffo review. But then when it came to the meeting in Boca Raton that occurred later, a few months later, excuse me, last year, the next year, her presentation fell flat because she was under the impression she was basically going to have to give the same kind of marketing dog and pony show, and she wasn't prepared to answer the financial questions that the NFL was looking for regarding, for example, tax increment financing or any kind of public financing, because Libby wasn't sophisticated in that area. And really, this time has received a complete baptism because the Athletics took my suggestion to Dave Cobble regarding using tax increment financing, fashioned that in the SB 293 Skinner. The governor, Gavin Newsom, approved that in October 11th of 2019, and then it fell into her lap and the city's lap with her as the mayor. And then it sat languishing as the legislative tool. No one did anything to call the county of Alameda and say, hey, we're going to use tax increment financing for Howard Term. We need to meet with you on this so we can start the public financing authority or start the and then write the infrastructure financing plan within it. None of that happened until the Major League Baseball Commissioner Manfred said on the 27th of March, hey, by the way, we got this letter about when you expect the groundbreaking to be, which is like 2027, and that's a bit too late beyond what we expected. So we're going to look elsewhere. And then, of course, that's when Las Vegas came up as the first alternative move. Now, you would say, when did they expect to break ground? 2021. This is now 2022, and we're looking at 2023 coming up on the horizon, okay? But look what's happened over there. You had, now for those who might say, well, hey, we had an active lawsuit that we lost. Well, even that lawsuit was brought forward by a fan-created coalition led by Ray Bobbitt, who's now the director of the African American Sports Entertainment Group, okay? That's far different from how it was done before, where the city and the city manager's office and the mayor drove the effort. In this instance, the fans had to convince the city to file suit. The city ignored them, didn't do anything. They kept pressing with folks like Dr. Death, Ray Perez, and Godfather Grizz, and Russ Rivera, number of great people. Rest in peace, Godfather Grizz. And yet, nothing. And Ray put up $40,000 of his own money to get the ball rolling, all right? To pay for Jim Quinn, the lawyer, to come out and try a rather esoteric, approach regarding battling and recovering damages from the move of the Raiders from Oakland to Las Vegas. And that's the difference. Bottom line, the city doesn't care this time. That's the difference. And you want the city to care. You want your elected official to care, to understand that, hey, an organization, a sports organization that carries the name Oakland becomes a marketing instrument worldwide, not just nationwide, but worldwide today for Oakland. Searches involving the name Oakland have went down on Google alone by 50% since both the A's and the Raiders have left. All right. They've done a tremendous amount of damage. But look what we've done. Instead of talking about rebuilding the Coliseum, growing and attracting other sports organizations, marshaling up investors who may very well be interested in sports, and then having a plan to make it work for them from a land development standpoint, we've done nothing. Nothing. And now we have people who don't understand and have this pseudo-intellectual idea that sports has nothing to do with economic development, has everything to do with it. We're in the place that we're in. So to answer your question, Dave, that's it. That's the answer to your question about what the city had done. I've got 5 minutes, and then I'm going to have to close this out and come back, and I'll come back later. But Jay Boogie says, if the current city mayor loses 3 major sports teams, that would have to be a record for a mayor. Yeah, that's true. A dubious record. How do you lose all 3 of your sports teams? Jay Boogie, stay tuned for my next show and today, and we'll sort that out, because this is a big problem. But I didn't get a call back from Mike Jacob, but he's going to come back later. So I'm going to close this out right now. And I want to thank everybody. And hey, thank you very much for the $10, Dave. Much appreciated from you. You've been a constant fueler of that kind of investment. So we love you for that. Anyway, subscribe to Zenny62 on YouTube and bookmark oaklandnewsnowblog.com. That ends this broadcast.